Hi friends, my name is Oleksandr. I'm a real estate lawyer at GOLAW law firm Ukraine. In this video, I want to give some important tips for investors who are planning to purchase commercial real estate in Ukraine. In particular, I want to talk about anti-monopoly clearance in real estate purchase deals. Imagine a situation when you are planning to expand your business in Ukraine or enter the Ukrainian market by the means of acquiring a certain commercial real estate asset. It can be grain storage or elevator, a hotel, a power plant, spirit plant, or any other asset or group of assets that can be used for certain business activity. In such a case, except due diligence and other preparatory actions, you shall pay special attention to the anti-monopoly clearance. According to Ukrainian laws, direct or indirect acquiring of ownership, management right, concession, or any other right of use of asset in the form of the entire property complex is deemed as a concentration. In its turn, the term entire property complex means all types of property including buildings, constructions, inventory, equipment, or integrated property complex, etc., which jointly provide a means for business activity. So, the key factor for understanding whether the purchase of a target asset falls under the definition of concentration is that the asset shall provide a means for certain business activity. For example, the privatization of the Dnipro hotel required prior approval because it can be used for the hotel services, as well as the purchase of ethanol production facilities of Ukrespirit by Nemiro required respective prior approval from the Antimonopoly Committee of Ukraine. Therefore, if you are planning to acquire the real estate object in Ukraine, please check whether such a purchase falls under concentration action or not. It should be noted, however, that not every concentration requires prior approval from the Antimonopoly Committee. The law defines special thresholds for the participants of concentration. Prior approval will be required only in case these thresholds are reached or exceeded. Namely, the prior approval of the committee for a concentration will be required in case the total assets value or goods turnover of the participants of concentration globally is more than 30 million euro, provided that assets value or goods turnover of each participant in Ukraine is more than 4 million euro. Or the total assets value or goods turnover of the seller is more than 8 million euro, provided that the value of goods turnover of the buyer is more than 150 million euro. Please note that calculation of the assets value or goods turnover shall be made with consideration of the control relations, which means that the value of the whole business structure worldwide, including related entities, shall be taken into account. So, in case the purchase of the target real estate object falls under the definition of concentration and the thresholds are exceeded, obtaining of prior approval of the Anti-Monopoly Committee of Ukraine for a concentration will be mandatory. In case the parties are not sure whether the purchase requires merger clearance or not, they can receive a preliminary conclusion from the committee regarding the necessity of a permission obtaining. It is essential that the approval shall be obtained before the transfer of ownership title to the buyer. Also, please note that the process of permission obtaining is complex and requires the provision of information and documents from both parties, seller and buyer. Therefore, it is strongly recommended to include provision governing anti-monopoly clearance to the sale and purchase agreement or preliminary agreement. To obtain the approval, the respective application to the Anti-Monopoly Committee of Ukraine shall be submitted. The standard term of the documents review by the committee is 45 days. Upon the documents review, the committee can adopt a decision on the permission of the concentration or its prohibition. The merger clearance is important because concentration without the prior consent entails a fine for the buyer in the amount of up to 5% of the annual income of the buyer's business group. It should be emphasized that the approval will be required regardless of whether the asset is sold on an auction or without it, whether the entire property complex is sold under one agreement or under several agreements, whether it's sold directly or through a corporate M&A, etc. Also does not matter whether this asset is proposed by a private seller or within a privatization procedure. So, in general, if you are ready to acquire real estate in Ukraine, you shall consider major clearance while structuring the deal and drafting the transactional documents. Check antimonopoly requirements with regard to the target asset. Check whether the thresholds are exceeded by the parties to a transaction or ask for the preliminary conclusion of the committee. And obtain prior permission for the concentration before purchase in case it is necessary. The mentioned steps will help you to avoid fines. Hope this was helpful. Please subscribe to see more and feel free to comment below. Stay safe. Goodbye.